Deep in the shadows, I know it's hard to put one foot in front of the other.
Under Rule 130, documentary evidence, a document that consists of writings, drawings, photographs, etc., or any material containing number, letter, etc. So, it is okay if the document is not written on a paper. Any material is okay. Once you present a document to prove a fact or issue, it becomes a documentary evidence. Multiple admissibility of evidence. A piece of evidence may be valid, not only to one, but two cases. Example, dying declaration exception to the hearsay rule must be made with full consciousness of impending death. Such may be used in wills and knowing who killed the deceased. Res gestae. It used to refer to a declaration that is made at an event that proves the event happened because the words were uttered upon witnessing the event. Collateral evidence. Evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Sabi nga ni Justice, ang collateral evidence raw parang the police, hindi raw yung nakakasakit pero nadaanan. Example, Pedro dies. Here, the witness told the court that he wasn't present during the killing, but the accused told him that something bad will happen to Pedro tonight. It is logical, thus collateral. However, if it is corroborated, then it will be admissible. Walang marriage certificate, di invitation ng kasal. Can baptismal certificate be proof of personage? Answer is yes, since it's a public document, it is admissible. What do you understand by the term admissibility? Admissibility is the ability of evidence to be accepted in court. To be admissible, evidence must be relevant and competent. What is the difference between relevance and competence? Relevance is the logical connection of the evidence, while competence means it should not be excluded by law or the rules of court. Example of an incompetent evidence, those in violation of the Constitution. So, do you mean all documents searched are incompetent? When does it become incompetent and competent? Competent when the requisites of evidence are complete, incompetent when it is not. Give me an example of unlawful search. When the search is without a warrant. Qualify. When the search is without a warrant and is not incidental to a lawful arrest. Example of irrelevant evidence. Murder. The deceased was stabbed. The knife, the accused for the stabbing, is the relevant evidence. So is it relevant? What should be the predicate? Evidence. Testimonies, facts, and circumstances. It must be the same knife showed and used in the killing. What are the types of evidence that are required for purposes of admissibility? Object evidence addressed to the senses of the court, documentary evidence, writing, photographs, etc., and testimonial evidence, perceived, perceiving, made known to the perception. Object, anything that the court can inspect or examine. Example of documentary evidence not in writing, CCTV, photographs. What are the several types of documents for purposes of admissibility? Original document, secondary evidence, and duplicate evidence. Are all the documents considered documentary evidence? When does a document become documentary evidence? Once it is used to prove a question of fact. Only questions of fact can be proved by evidence. What is an electronic evidence? Any probative information stored or transmitted in digital form that a party to a court case may use at trial. What makes it electronic? The fact that it is generated electronically and then offered to prove a fact in issue. What is the original document rule? No evidence is admissible other than the original document itself. Example, when is it considered an original document? When the document is the document itself or any counterpart intended to have the same effect. When the contents of the document is needed by courts, original lang ang pwede. Are there exceptions to the original document rule? Yes. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. Number 2, when the original is in the custody or under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. 3. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. When the original is a public record in the custody of a public officer or is recorded in a public office, and when the original is not closely related to a controlling issue. Judicial inquiry, what does it mean? A formal legal investigation conducted into a matter of public concern by a judge appointed by the government. What kind of document is needed for it to be an original evidence? Any document. A plane ticket is a document, so a plane ticket can be an original evidence. About a promissory note, subject sa inquiry ang contents, what does that mean? It means that the issue will be how much is the total obligation. It is stated there when to pay or how to pay. Here, the original document or evidence is the promissory note because all the contents needed to prove or to answer the issue is there. In law, terms are important, so you must complete the rule. There are conditions, exceptions, general rules. This is important to know, especially in exceptions. You must know the prerequisite on how it is an exemption. Example for the second exception. When the contract of sale is in the hands of the adverse party and it cannot be obtained. Why is it an exception? Why can't it be introduced or produced in court? Because secondary evidence na ang pwede mo ibigay kasi wala just cause yung pag-deny or pag hindi nagbigay ng original evidence kasi nga yung may hawak yung adverse party. So example for the third exception. Company tax ITRs. The court may order just the relevant ITRs or the summary computation. If the original consists of documents enumerating accounts, that is not really an exception. How or when does it become an exception? Number 1, the fact is sought by the court. 2, there is great loss of time. And 3, only the general result is needed. Thus, the summary is enough. Most important. When does Rule 130, Section 3, letter C become an exception? When the fact of the evidence is sought by the court. When there is a great loss of time, if such documents will be examined, and when only the general result is needed by the court. Thus, the summary is enough. When is the document a public document? When it is issued by the government. How? Example. When an OTC is registered in the Register of Deeds. There is another kind of document, the official document. Public document versus official document. Public document is any document issued by the public officer in relation to his public office. Official document is a document originating from a public institution issued in the exercise of his functions. There is special significance and national interest. This is immediately admissible in courts. Example of public document, medical certificates issued by a public hospital or BIR. Examples of official document, Act of Congress, judgments of courts. In both, there is no need for authentication. All that is needed is justification. Now, what does a duplicate or what does duplicate mean? It is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. What is the predicate condition for it to be a duplicate? You must use the equivalent techniques. Duplicate evidence. This is the same as the original. It is produced or reproduced with the equivalent techniques, which accurately copies the original. Secondary evidence. This is only the substitute when the original document is unavailable. Example of duplicate evidence. Example, when the original MOA is lost, but there is a soft copy and the person reprints it. Example of secondary, if there is no baptismal certificate, the invitation for the baptismal party as long as the important contents which are needed are present. If a policeman gives you a copy of a page in a police blotter, what is that? Public document, but it must be signed by the police officer in charge. Original document rule, parole evidence rule, and other evidentiary rules. Parole evidence rule. A parole evidence rule forbids any addition to or contradiction of the terms of a written agreement by testimony or other evidence purporting to show that different terms were agreed upon by the parties, varying the purport of the written contract. What is the subject of parole evidence rule? The terms of the agreement. Original document rule, or ODR, versus parole evidence rule, PER. Under ODR, or original document rule, the subject of judicial inquiry is any kind of document, while under parole evidence rule, the subject of judicial inquiry must be agreement, contract, or a will specified in law. This is an exclusive list. What kind of evidence is not allowed in parole evidence rule? Extraneous evidence or evidence aliunde. This is an evidence which is detached from and not connected with or a collateral evidence. Can parole evidence rule be given orally? Yes. What is important is that it should never be an evidence aliunde. When the terms of agreement is put in contract, no other evidence can be put in that agreement. In PER, or parole evidence rule, there is only an agreement. Unlike in original document rule, any kind of document, as long as it is the original, generally, it is fine. Parole evidence rule is evidence aliunde, or outside the contract. Examples of PER: in a contract of sale of a car, what is needed are the subject, consideration, parties, etc. If the issue is whether or not the amount given is enough consideration, PER comes into play. Since it is an outside document, and since it is an agreement, you will have to show it to prove that the consideration is enough or not. Kunwari, a will is being probated and the heir claims that may land pa siya na wala sa will. Justice said that you cannot present evidence that does not appear in the document. If it is not in the document, hindi mo pwedeng dagdagan or ibahin ng nakasulat sa document. Are there exemptions to PER? Yes. An intrinsic ambiguity, mistake, or imperfection in the written agreement. The failure of the written agreement to express the true intent and agreement of the parties thereto. The validity of the written agreement, or the existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. Ano yung predicate requisites muna? You must plead it in your answer that there is an issue that you will add in the document. Example of pleading: there is a contract of land, barangay, etc. Tapos X will buy it. However, my same barangay nang ganun ang name. So ano yung subject ng sale? Hindi naman pwedeng dalawa yun. So to be allowed, you plead that there is ambiguity. Also state mo, barangay, etc. Makati. Exceptions to PER. 1. Plaintiff pleads in a verified complaint the existence of the original and the destruction of the original. Number 2, when you allege to present evidence aliunde, evidence of the existence of a contract, evidence of destruction. Number 3, when the original is with the other party, existence of the original, the unjustified failure to comply by the other party. Number 4, validity of the contract is challenged. You can prove this by PER. Number 5, agreements entered into which novates, adds, or retracts. Existence of the contract. Contract must be void. The reason why it is void. 6, agreements failed to show its true intention issued by the usurers. An example would be, what is prepared is a deed of sale and not mortgage. However, even if the title says deed of sale, but the whole document means a mortgage, then there you need PER. Number 7, when there are other agreements entered into by the parties after such, novation is an example of something that can be submitted without further proof. Interpretation of documents. General rule: when a term is clear and unambiguous, there is no need for interpretation. Exception: when ambiguity or when it is capable of 2 or more meanings, interpretation is needed. When is interpretation needed? When the terms are ambiguous or there is ambiguity, when there are conflicting provisions, when the terms are susceptible of two or more explanation, or when there are conflicting provisions. General rules of interpretation. The title of the document doesn't control or indicate the contract. It is the body of the contract which controls the entire document. All the provisions should be harmonized in the sense that all provisions be given effect, if possible. In case of doubt, the contract should be interpreted as one with the least transmission of rights, and when the terms in the contract can be interpreted in two or more ways, that which supports natural rights shall be followed. Printed versus written, the printed one shall prevail. General versus specific, the specific one shall prevail. Original document rule. It is when the subject of inquiry is the contents of a document, writing, recording, photograph, or other record. No evidence is admissible other than the original document itself. Exceptions as per the amended rules. Number 1. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. 2. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedure. 3. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. 4. When the original is a public record in the custody of a public officer or is recorded in a public office. And 5. When the original is not closely related to a controlling issue. Duplicate of the original. This is new. It is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronical re-recording, or by chemical reproduction, or by other equivalent techniques, which accurately reproduce the original. Exceptions. When there is a question regarding whether or not such document is genuine, syempre ang duplicate will not be admitted, and if it appears to be unjust to admit the duplicate. Secondary evidence. When the original document is unavailable, when original document is in adverse party's custody or control. 3. When the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the fact sought to be established is only the general result of the whole. The contents of such evidence may be presented in the form of a chart, summary, or calculation. The original shall be available for examination or copying, or both, by the adverse party at a reasonable time and place. The court may order that they be produced in court. Hearing versus trial. Hearing, more generic, presentation of evidence or presentation of argument. It is the reception of evidence and other processes. It embraces the period for the introduction of evidence by both parties. Under trial, it always involves presentation of evidence. It is not confined to trial, but embraces the several stages of litigation, including the pre-trial stage. A hearing doesn't necessarily mean presentation of evidence. It doesn't necessarily imply the presentation of oral or documentary evidence in open court, but that the parties are afforded an opportunity to be heard. Testimonial evidence. Important note, all these privileges or exemptions do not apply in criminal cases, only in civil cases. Testimonial evidence, evidence elicited from the mouth of a witness as distinguished from real and documentary evidence. This has the least weight, if incredible. Witness, a person who testifies in a case or gives evidence before a judicial tribunal. Qualification of witnesses: can perceive, to observe, to perceive, to remember, and 3, can make known their perception to others, to relate. Factors which do not disqualify a witness: religious belief, political belief, interest in the crime, outcome of the case, conviction of a crime. When the person is so connected to a crime or the outcome of the crime, it is okay. Usually naman, that is the kind of witness that the other party would not want to testify. So kahit ganoon, pwede pa rin. Pero minimal effect yung testimony niya. So what's important is the weight of evidence pa rin. Testimony can be verbal. Remember that verbal is different from oral or sign language. So can a deaf mute testify? Answer is yes. It's that they can perceive and communicate it the way they can. So can children testify, like special children? Yes, especially if they can perceive and communicate it the way they can. Voir dire rule, an examination for confidence or competence examination, or it is a preliminary examination conducted by the trial judge where the witness is duly sworn to answer as to his competency. Example, whether or not the child is capable of knowing the difference between right and wrong, oath has the capacity to convey. Test of competency, whether or not the witness is capable of understanding the duty to tell the truth. Competency of a witness. Credibility of a witness equals to credibility of a witness. Unsound mind or insanity, this must occur at the time. Thus, the person has the capacity to testify if he is on a lucid interval. Presumption of competency. General rule. When a witness takes the witness stand, the law on ground of public policy presumes that he is competent. Exemptions. Judicially declared of unsound mind or an inmate of an asylum for the insane. Can a court compel a person to testify? It depends. If he is a party and ayaw, di pwede magtestify due to the Miranda Doctrine, right to remain silent. However, if ordinary party, he may be compelled under a subpoena, which is only good within 100 kilometer. So when a court is in Muntinlupa and subpoena is issued to someone from Bicol, that witness can deny. But if hindi siya pumayag and within 100 kilometers naman siya, edi maares siya, bench warrant. What is a bench warrant? The court can compel any person to testify, and if ayaw, the court can give a bench warrant to arrest him to testify. Persons who cannot be issued a subpoena. President, congressmen, senators, judges, justices, diplomats. Exception to testimonial evidence, disqualifications. 1. Disqualification by reason of marriage. Disqualification by reason of death or insanity of adverse party. Disqualification by reason of privileged communication. Communication between spouses, spousal immunity. Communication between attorney and client. Communication between physician and patient. Communication between priest and penitent and public officers and public interest. Number 4, those not domiciled in the Philippines. 5. Those convicted of falsification of documents, perjury, or false testimony from being a witness to a will. 6. State witness. Or 7. A lawyer on formal matters or on substantial matters. Marital disqualification by reason of marriage privilege. It must be done in confidence, and such privilege extends even beyond marriage. Exceptions. When the testimony was made outside of marriage. 2. In a civil case by one spouse against the other. 3. In a criminal case for a crime committed by one spouse against the other or the latter's direct descendants or descendants. 4. Where the spouse gives his or her consent. And 5. Where the spouse fails to raise the disqualification seasonably. Dead man's statute. Survivorship disqualification rule. Here, the deceased is presupposed to leave an estate. The claimant against the state is the plaintiff. The defendant is the executor, representative, or heir. No evidence can be presented that could vary. No claim can be entertained unless there is proof that it was independently made. If there is claim, it is chargeable to the estate. Reason? A dead man can no longer refuse a claim. The rules pertain to property, real or personal, and other matters of fact. There can be no fact or information that was secured before the death that could vary the interest in the state. Can you file a writ of mandamus for your wife to have sex with you? No. The writ of mandamus does not apply to married couples, as it is a writ specified for a legal act to be mandatorily acted upon. Can you file a writ of mandamus against your parents to make you study or have you enrolled if they don't want you to? Yes, because that is a right. Thus, it is legally demandable. Requisites of dead man's statute. The witness is a party or a signer of a party to a case or persons in whose behalf a case is prosecuted. 2. The action is against an executor, administrator, or other representative of a deceased person or a person of unsound mind. 3. The subject matter of the action is a claim or demand against the state of such deceased person or against person of unsound mind. And 4. The subject matter of the testimony refers to any matter of fact which occurred before the death of such deceased person or before such person became of unsound mind. Privileged communication found in the rules of court. 1. Communication between spouses. 2. Communication between attorney and client. 3. Communication between physician and patient. 4. Communication between priest and penitent. And 5. Public officers and public interest. Spousal immunity, spousal privilege. Information given in or during the marriage. If there is a case involving the spouse, the other spouse is disqualified to testify against the party's spouse. Any information cannot be disclosed, may it be documentary, object, or testimonial. A marriage is a contract. Therefore, there are mutual obligations. What is your obligation to your spouse? Your primary obligation is to love and be faithful until death and even beyond. So if you're unfaithful, you are breaching the contract. Requirements of spousal immunity. The spouse for or against whom the testimony is offered is a party to the case, unless there is consent allowing one spouse to testify against the other. 2. The spouses are legally married, valid until annulled. This means that neither marriage must not be estranged, nor that they are just cohabiting with each other. The reason for this is to preserve the sanctity of marriage. If there is no objection, however, it could be admitted. Can a wife testify against the husband if the husband raped their child? Yes. Under the law, it is part of the exceptions where in a criminal case for a crime committed by one spouse against the other or the latter's direct ascendants or descendants. Paano if may third party na nakarinig? Can the third party testify? Spousal privilege yung pinag-uusapan tapos narinig niya lang? Yes, pwede because the third party isn't part or isn't covered by the spousal privilege. 3. Testimony is offered during the existence of the marriage. And 4. The case is not one of the exceptions provided in this rule. Attorney-client privilege communication. In connection to the engagement or negotiation, any information and or piece of advice is considered privileged matters. Thus, this cannot be divulged. Can you reprint an affidavit of a case if the accused is running for mayor and he's a rapist? Yes, of course. The Supreme Court allowed it as long as there is consent from the family of the alleged rapist and the accused himself. Requisites of attorney-client privilege. There is an attorney-client relationship or a kind of consultancy relationship with a prospective client. The privilege is invoked with respect to a confidential communication between them made in the course of or with a view to professional employment and the client has not given consent to the attorney's testimony thereon, or if the attorney's secretary, stenographer, or clerk is sought to be examined, that both the client and the attorney have not given their consent thereto. Exception from the Code of Professional Responsibility. When authorized by the client after acquainting him of the consequences of the disclosure. 2. When required by law. 3. When necessary to collect his fees or to defend himself, his employees or associates, or by judicial action. Physician-patient privilege communication. When a patient consults a doctor or any advice given to the patient, this is privileged and aims to protect the privacy of the parties, most especially the patient. Requisites of physician-patient privilege. 1. The privilege is claimed in a civil case. 2. The person against whom the privilege is claimed is one duly authorized to practice medicine, surgery, or obstetrics. 3. Such person acquired the information while he was attending to the patient in his professional capacity. 4. The information was necessary to enable him to act in that capacity. And 5. The information was confidential and, if disclosed, would blacken the reputation of the patient. Note, this privilege is waivable and applies only to civil cases. The court can require the disclosure. However, hospitals cannot be compelled to release records of its patients. When the question has nothing to do with the ailment, would that still be categorized as privileged? It is covered as long as it has the tendency to destroy the reputation of the patient. It is stated in the requisites would blacken the reputation of the patient. Priest-penitent privilege communication. Requisites of priest-penitent privilege. The confession must have been made to the priest in his professional character in the course of discipline enjoined by the church to which he belongs in. And 2. The communications made were confidential and penitential in character. These are revelations made during confession because in Catholicism there is this thing called seal of confession. Once such seal is disclosed without permission, there would be sin. Privileged communication to public officers. Requisites of privileged communication to public officers. The holder of the privilege is the government acting through a public officer. 2. The communication was given to the public officer in confidence. 3. The communication was given during the term of office of the public officer or afterwards, and the public interest would suffer by the disclosure of the communication. If you're a public officer, you learn a lot of matters which are by their nature confidential. Thus, you cannot disclose it. That is obvious. Public interest, something in which the public, the community at large, has some pecuniary interest by which their legal rights or liabilities are affected. Exceptions wherein disclosure may be compelled. 1. Useful evidence to vindicate the innocence of an accused person. 2. To lessen risk of false testimony. 3. Essential to the proper disposition of the case. 4. The benefit to be gained by a correct disposition of the litigation was greater than any injury which could inure to the relation by a disclosure of information. Privilege in bank deposits. What are covered? Deposits in banks or banking institutions in the Philippines. 2. Investments of bonds issued to the government or political subdivision. 3. It is prohibited to examine bank records of any official, bureau, or office. Exceptions from RA 1405. 1. When it is authorized in writing by the depositor. 2. Impeachment in cases of bribery or dereliction of public funds. 3. Litigation. 4. Anti-graft cases. Or 5. In cases where the money deposited or invested is the subject matter of the litigation. CJ Corona case and CJ Sereno case. Under CJ Corona case, dollar deposits in PS Bank that is worth $85,000. He did not put it in his SALN. The president of PS Bank refused and used the dollar secrecy law as his basis for his refusal. However, na contempt of court siya. In Sereno case, failed to produce ASLN na 7 years na worth. For ASLNs lang ang pinasa niya sa requirements, so kulang siya. But this is daw just an internal rule of the JBC. Nonetheless, nominated si Girl as Chief Justice. So sabi ni Justice Aquino, isn't that estoppel already, cause despite the shortage in the submission, she was already shortlisted? Okay, you can read the case. Other privilege matters. 1. The guardian ad litem shall not testify in any proceeding concerning any information, statement, or opinion received from the child in the course of serving as a guardian ad litem, unless the court finds it necessary to promote the best interest of the child. 2. The publisher, editor, or duly accredited reporter of any newspaper, magazine, or periodical of general circulation cannot be compelled to reveal the source of any news report or information which was revealed in confidence to him, unless the court or the House finds that such revelation is demanded by the security of the state. Voters may not be compelled to disclose for whom they voted. 4. Trade secrets. And 5. Bank deposits. Your bank will not disclose without your consent. However, there are exemptions. Anti-Money Laundering Council, AMLC, can investigate suspected ill-gotten wealth. 6. Security matters. 7. Foreign affairs. 8. Tax returns except when it is needed in cases. 9. SALNs except when it is needed in cases. 10. The person you voted for. And 11. Hospital records. What is attorney-client privilege? Disqualifications of testimonial privilege. Disqualification of a witness. A parishioner engaged priest in a conversation. Is that privileged communication? For it to be privileged, what should be the requisites? And what does privilege mean? Privileged communication. It's a communication which cannot be disclosed without the consent of the other party. What is the effect of confidentiality? What is protected? This privilege covers not only lawyers but also a person whom the client believed to be a lawyer, a proxy of a lawyer, or someone they disclosed any negotiation to. Who else is covered by the attorney-client privilege? Explain the spousal privilege communication. What are the requisites? Example of a spousal privilege communication. Example of something that is not privileged. What is not privileged? When does an information become relevant? Are there exceptions to this rule? Is this exemption limited to the spouses? Are there exceptions? And what are the exceptions? So, different privileges: parental and filial privilege, and privilege relating to trade secrets. The parent and filial privilege, parental, is the witness cannot be compelled to testify against his child or other direct descendants. Filial, the witness cannot be compelled to testify against his parents or other ascendants. Reason? In accordance to our culture, closeness of family ties. Siyempre, if that is not controlled, maraming perjury na yan. Trade secrets. A person cannot be compelled to testify about any trade secret. Exception? If the non-disclosure will conceal fraud or otherwise work injustice. Admissions and confessions. Admission, an extrajudicial or voluntary statement or acknowledgement of the existence of the truth of certain facts which are inconsistent with his claim in an action. Confession, the declaration of an accused acknowledging his or her guilt. Admission versus confession. Under admission, acknowledgement of the fact and issues, but does not involve acknowledgement of guilt. Let's say A said he stabbed B. This does not necessarily mean A is guilty, as he just acknowledged the fact that he stabbed B. Pwede naman siya as self-defense. Pwede the third person mag-make ng admission and pwede rin siyang expressed or implied. Under confession, this pertains to the admission of any kind of guilt. A said, "Oo, sinaksak ko si B hanggang mapatay ko siya." Made only by the party himself and lagi siyang express. Admission and confession can be 1. Extrajudicial, not made in court. Express, made in a definite, certain, and unequivocal language, or implied, those which may be inferred from the act, conduct, declaration, silence, or omission of a party. 2. Judicial, made in court in the cause of the proceeding. Formal, made in writing, or informal, made orally. Kinds of admission. 1. Admission by third party will be discussed later under res inter alias acta. Number 2, admission by co-partner or agent. 3, admission by conspirator. 4, admission by privis or privis. And 5, admission by silence. Admission by a co-partner or agent. The act or declaration of a partner or agent authorized by the party to make a statement concerning the subject or within the scope of his or her authority and during the existence of the partnership or agency may be given in evidence against such party after the partnership or agency is shown by evidence other than such act or declaration. Requisites of ABCA. The act or declaration of a partner or agent of the party must be within the scope of his authority, made during the existence of the partnership or agency and after the partnership or agency is shown by evidence other than such act or declaration. Admission by conspirator. The act or declaration of a conspirator in furtherance of the conspiracy and during its existence may be given in evidence against the co-conspirator after the conspiracy is shown by evidence other than such act of declaration. Requisites of ABC. The conspiracy must be first proved by evidence. 2. Admission relates to a common object. And 3. Made while declarant engaged in carrying out the conspiracy. Admission by privies. Where one derives title to property from another, the latter's act, declaration, admission in relation to the property is evidence against the former if done while the latter was holding the title. Requisites of ABP. There must be an act, declaration, or omission by a predecessor in interest. It must have occurred while he was holding a title. And 3. The admission relates to the property. Admission by silence. An act or declaration made in the presence and within the hearing of or observation of a party who does or says nothing when the act or declaration is such as to naturally call for action or comment, if not true, and when proper and possible for him to do so, may be given in evidence against him. Requisites of ABS. He heard or observed the act or declaration, and he was at liberty to make a denial. 3. He must have understood the statement. 4. The facts were within his knowledge. 5. He must have an interest to object, such that he would naturally have done so if the statement was not true. And 6. The fact admitted or the inference to be drawn from his silence is material to the issue. Plea of guilty, arraignment, judicial. Declaration before the police during a police investigation, extrajudicial. Judicial admission versus extrajudicial admission. In judicial admission, weightiest probative value, almost conclusive. In extrajudicial admission, either admissible or inadmissible, it must be assisted by a lawyer. If not, inadmissible. When is an admission admissible? Involve matters of fact and not of law. Be categorical and definite. 3. Be knowingly and voluntarily made. And 4. Be adverse to the admitter's interest, otherwise it would be self-serving and therefore inadmissible. Self-serving statements, general rule. Unsworn statements made by the declarant out of court and which are favorable to his interest. These are untrustworthy declarations and open to fraud and fabrication. Exceptions, when they form part of res juste. 2. Testimonial rehabilitation. 3. Offered by the opponent. 4. Offered without objection. 5. In the form of a complaint and exclamations of pain and suffering. And 6. Part of a confession offered by the prosecution. Note, an admission is an evidence against a declarant. Judicial admission is different. Compromise. A compromise is a contract whereby the parties, by making reciprocal confessions, avoid a litigation or put an end to one already commenced. Offer to compromise. In civil case, general rule, not an evidence against the offender. It is the policy of the law to favor the settlement of disputes, to foster compromises, and to promote peace. The plaintiff offers to compromise. Sa barangay level pa lang. In court, once it is filed, can you compel the Lupon barangay to disclose? Yes, but wala naman probative value yan. Quasi-offenses can be compromised. Criminal offenses, compromise is a sign of guilt. It is an evidence of guilt and is admissible in court. Exception, when such offer is clearly not only to buy peace but amounts to an admission of liability, the offered compromise being directed only to the amount paid. Vehicular accidents, brings to the hospital and pays the bill, not admissible in evidence in both the civil and criminal aspect, e.d. torts. In criminal law cases, general rule, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. When a person in a criminal case pleads guilty, that is allowed, also if for a lesser offense. Any kind of change of plea is not an admission of guilt. A recantation of a person, I killed tapos biglang I did not kill, is admissible, but the weight of the evidence is very important. If an accused is willing to be a state witness, an affidavit must be prepared stating that his co-accused did the crime and he is not the most guilty among them. Exceptions: 1. Plea of guilty, later withdrawn. Tax cases. 3. An offer to pay, or the payment of medical, hospital, or other expenses occasioned by the injury. 4. Quasi-offenses or criminal negligence. 5. An unaccepted offer of plea of guilty to a later offense. 6. Covered by Katarungang Pambarangay, and 7. BP 22. No compromise is allowed in the following: 1. Civil status of persons, validity of marriage or legal separation, any ground of legal separation. 4. Future support. 5. Jurisdiction of courts. 6. Future legitimate. And 7. Habeas corpus in election cases. Confession and kinds of confession. Confession, this pertains to admission of any kind of guilt. Judicial confession, one made by the accused before a court in which the case is pending and in the course of legal proceedings. Extrajudicial confession, declaration of an accused acknowledging his guilt of the offense charged or of any offense necessarily included therein. Res inter alios acta. Rule 130, Section 29, admission by a third party, and Rule 130, Section 35, similar acts as evidence, propensity rule. Now, under 130, Section 29, admission by a third party, the rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as hereinafter provided. Similar acts as evidence. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he or she did not do the same or similar thing at another time, but it may be perceived to prove a specific intent or knowledge, identity, plans, system, scheme, habit, custom, or usage, and the like. Res inter alios acta means the act or omission does not affect the other person. Hampas sa kalabaw, latay sa baka. Hindi pwede ibang tao ang sasalo. Previous deeds or acts, previous penalties, not an evidence to prove he will do the same thing. So, for example, if estafador siya noon, di ibig sabihin estafador pa rin siya ngayon. That is not admissible as evidence. Exceptions. Admission by a co-partner or agent. Number 2, admission by previous. 3, interlocking confession. 4, admission by a conspirator. Conspiracy, 2 or more persons plan to commit a crime which is then subsequently done. The act of one is the act of all. ABC allegedly killed Juan de la Cruz. A executed a confession that they killed Juan de la Cruz. Is that admission by B and C? No, only against A. Under the rule, however, such will be different if A admits it all of a sudden in court because suddenly A is open to cross-examination, and 5, admission by silence. Propensity rule, general rule, evidence that one did or did not do a certain thing at one time is not admissible to prove that he did or did not do the same or a similar thing at another time. Evidence is not admissible when it shows that the accused has committed a crime, independent from the offense for which he is on trial. That is the propensity rule. Exceptions: specific intent, identity, system, custom, usage, knowledge, plan, scheme, habit, and the like. An accepted offer. An offer in writing to pay a particular sum of money or to deliver a written instrument to a specific personal party. Hearsay. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. It could be oral or written or nonverbal conduct of a person. General rule: inadmissible. Because the person who testified cannot be examined, thus it cannot be proved if it is credible or not. Exception. Dying declaration. The declaration of a dying person made under the consciousness of an impending death. Requisites. Made by a dying person under the consciousness of death. Number 2, the declaration refers to the cause and surrounding circumstances of such death. 3, it was made by a declarant competent to testify as witness had that person been called to testify. 4, the statement is complete in itself. 5, the declarant died. And 6, the declarant's death is the subject of the inquiry. Statement of dissident of person of unsound mind. In addition, against an executor or administrator or other representative of a deceased person, or against a person of unsound mind, upon a claim or a demand against the state of such, and a statement of the deceased or person of unsound mind may be received in evidence if it is done upon the personal knowledge of such. Requisites. There is an estate in question. 2, the estate is owned by the deceased or person of unsound mind. 3, such estate has an assigner who testifies. 4, the deceased or person of unsound mind has made a statement based on personal knowledge regarding the estate. And 5, such statement is made when the deceased was still alive and the person of unsound mind was not yet declared as such, or his or her recollection is clear. And 6, the statement is trustworthy. Declaration against interest. It is a declaration made by a deceased person or someone unable to testify against the interest of a declarant. Requisites. It relates to a fact against the interest of the declarant. Number 2, at the time he made said declaration, the declarant was aware that it was contrary to his aforesaid interest. The declaration must be made out of court, extrajudicial statement. And 3, the declarant had no motive to falsify, and he believed such declaration. Act of declaration about pedigree includes relationship, family, genealogy, birth, marriage, death, etc. Requisites. The declarant is already dead or is unable to testify. Number 2, the declarant must be a relative of the person whose pedigree is in question. 3, the pedigree is a person must be at issue. And number 4, the relationship between the declarant and the person whose pedigree is in question must be shown by evidence other than such act or declaration. And 5, the declaration must be made before the controversy has occurred. Family reputation or tradition regarding pedigree. The reputation or tradition existing in a family previous to the controversy may be received in evidence. Requisites. 1, there is a controversy in respect to the pedigree of any of the members of a family. 2, the reputation or tradition of the pedigree existed previous to the controversy. And 3, the witness testify as a member of the family of the said person. Common reputation. The definite opinion of the community in which the fact to be proved is known or exists. Wala siyang requisites pero examples kung saan siya pwedeng magamit. 1, boundaries of or customs affecting lands in the community and reputations as to events of general history important to the community. Pwede maisama ang monuments and inscriptions in public places. Res gestae. Records of regularly conducted business activity. A memorandum, report, record, or data compilation of acts, events, conditions, opinions, or diagnosis made by writing, typing, electronic, optical, or other similar means by a person with knowledge thereof and kept in the regular course or conduct of a business activity, and such was the regular practice. Requisites. This is new, but Justice Echele mentioned that this is an exception to the hearsay rule because it's impractical papupuntahin lagi yung mga may hawak ng records and documents sa court to reiterate what is written there. Since official documents naman daw siya, or records, it means it stands as the witness itself. In other words, yung document na mismo or record yung witness. Entries in official records made in the performance of a public officer's duty or by a person specially enjoined by law. Requisites: it was made by a public officer or by another person specially enjoined by law to do so. Number 2, it was made in the performance of their duty. And 3, they have sufficient knowledge of the facts stated by him, which he must have acquired personally or through official information. Commercial list and the like. It is an evidence of statements of matters of interest to persons engaged in an occupation contained in a list, register, periodical, or other published compilation. Requisites: 1. Statements of matters of interest to persons engaged in an occupation. 2. The statements must be contained in a list, register, periodical, or other published compilation. And 3. That compilation is published for use by persons engaged in that occupation. And 4. It is generally relied upon them. Now learn 3 theses. Published treatise, periodicals, or pamphlet on a subject of history, law, science, or art. Requisites: the court takes judicial notice of it. And 2, a witness expert in the subject testifies that the writer of such is recognized in his profession or an expert in the subject. Testimony or deposition at a former proceeding. The testimony or deposition of a witness deceased or out of the Philippines or who cannot with due diligence be found therein, or is unavailable or otherwise unable to testify. Requisites: 1. The witness is deceased or unable to testify. 2. His testimony or deposition was given in a former case or proceeding, judicial or administrative, between the same parties or those representing the same interest. 3. The former case involved the same subject as that in the present case, although on different causes of action. Number 4, the issue testified to by the witness is the same issue in the present. And 5, the adverse party had an opportunity to cross-examine the witness in the former case. Residual exception. A statement not specifically covered by any of the foregoing exceptions, and this is new. Pero ito, sabi ni Codal provision, having equivalent circumstantial guarantees of trustworthiness is admissible if the court determines that 1. The statement is offered as evidence of a material fact. 2. The statement is more probative on the point for which it is offered than any other evidence which the proponent can procure to a reasonable effort. And 3. The general purposes of these rules and the interest of justice will be best served by admission of the statement into evidence. Res geste. Spontaneous statements versus verbal acts. Under spontaneous statements, statements made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence. So the code word is startling occurrence and stress of excitement. Requisites. The principal acts are the startling occurrence and the stress of excitement. 2. The statements were made before the declaration had time to contrive or devise. And 3. The statements concern the occurrence in question and its immediately attending circumstances. Now, under verbal acts, these are statements accompanying an equivocal act material to the issue and giving it legal significance. Code word, equivocal act. Requisite, the principal act to be characterized must be equivocal. The equivocal act must be material to the issue. And 3, the statement must accompany the equivocal act. And 4, the statements give a legal significance to the equivocal act. Additional notes of Justice HLA. 1. Independently inadmissible evidence. This is also an exception, but this is just not included in the table. When a person is presented not to prove the truth, but to prove that on the occasion which is relevant to the case, he was there when the person quoted something. Example, witness testified that he had a conversation with J. J said that A killed B. But if that conversation is to prove a conversation, It is independent of the admissible evidence. It is offered to prove the truth, but not to prove that he was there and he heard something, because presence is relevant and is a proof that he was a relevant matter. Example, witness testified that he hears A telling C that he killed B, and later that day, the news broke out that B was stabbed by an old friend. The witness was there. Dying declaration. When a person is dying and he makes a statement with full awareness that he is going to die, magsasabi yan ng cause of death. Yon, it may be testified. Cause, even if di alam ng witness paano nasaksak, alam niya naman kung sino. That is important because the dead man could no longer testify for himself. A dying man will never tell a lie. If a supposedly dying person did not die because of medical intervention, pwede siya maging admissible pa rin as res gestae, another type of exception. There must be consciousness of death. Hindi consciousness of death yung magsasabi na bahala ng Diyos. If hindi pa mamamatay, pwede pa yung magsisinungaling. Res gestae, when in an occasion of a startling event, a person had heard somebody shouting pertaining to who did such disturbance. Example, A shouted, "Bakit mo naman sinunog yung bahay B?" The quotation is admissible since there is no time to invent stories. If there is a certain time in between, di na admissible yun kasi pwede mag-invent ng story. Declaration against interest. The person makes an extrajudicial statement that he is only leasing a property, and then a case is brought to court. Then in court, he will say that sa kanya yung lupa. Kapag may nakarinig na nagsabi niyang extrajudicial statement na lessee lang siya, that's admissible against the interests of the declarant. Kung hindi totoo, bakit mo sasabihin? If in favor sa'yo that it is a self-serving statement, that's not admissible. 5. Common reputation. Members of the same family magte-testify and yung party. Sabi ni Justice, ang common reputation daw, hindi yun rumor or chismis. Kasi raw ang rumor walang basis, pero ang reputation daw makikita ng maraming tao or yung action towards the community.